Gangs are about to get smacked with a tsunami of laws they're not going to like. Very soon, our gang legislation will pass its final hurdle in Parliament, the third reading. What it does is give the police extra tools to deal with gangs in our community.
Kia ora, I'm Amanda Gillies, and today on The Detail, has the government's war on gangs gone too far?
Gang patches will be banned in public and police will be given extra powers to stop gang members congregating.
No gang patches, no branding, no gang gatherings in public. This morning's announcements are tough talk.
Labor says it's impractical and a law professor calls it a political gimmick.
But others, including the Police Association, say it'll help reduce a ballooning gang population.
To ban or not to ban, two sides, two clear arguments.
Gangs, they need to be taken down. We need to give the police absolutely every tool.
They're not above the law. Everyone seems to think that they can ignore our laws and they're above the law. They're not.
Challenge after challenge was laid down opposing the move.
It is a limit of freedom of expression that is unjustifiable.
What they serve to do is to increase the view of society of an us and them situation.
They got their uniform, the police, and we got our uniform. This one here overrules their one.
If they want a war, that'll start a war.
Now the Gangs Bill controversy has just become more controversial with an 11th hour edition with no public consultation.
It is not good rulemaking, despite being good politics, and you could call it pretty sneaky.
So, on The Detail today, the Gangs Bill, which has just passed its third reading with a late edition that has opponents outraged. The Justice Minister, Paul Goldsmith, initially rejected a police request to ban gang patches in the private homes of repeat offenders, but then changed his mind. So how and why did this happen, and what are the implications of the new clause?
We expect better of our lawmakers, and those affected by the law quite rightly and appropriately expect to be consulted about significant changes in that law.
That's lawyer Chris Macklin, the convener of the Law Society's Criminal Law Committee. We'll hear more from him in a moment. But first, Derek Cheng. He's a former political reporter, now senior writer for the New Zealand Herald. He's covered the story since day one and describes the clause addition as significant.
This came from police. It was in March, the end of March, they sent the Police Minister, Mark Mitchell, a paper outlining their concerns that gang members would just wear their gang patches in public, which is part of this bill, which will be outlawed as part of this incoming bill. And they wanted to have a system of escalating penalties to deter that, kind of like a three strikes thing. And they gave Mark Mitchell a whole list of options. And the government has decided to adopt some of them or most of them, but not all of them. So, I mean, they wanted the penalty for a public gang patch to double for the second strike, and for the third strike to have a mandatory prohibition order. And under that order, an offender who has breached that public ban 3 times in 5 years will not be able to have a gang patch in their possession at all, whether in public or private. And they also won't be able to have one in the place where they where they live. So that second aspect is quite a significant change because it impacts everyone that they live with, their rights to freedom of expression and assembly, peaceful assembly, etc. And also like visitors to their home. So, if a visitor comes to your house and you're under this prohibition order and they're wearing a patch jacket, then you're in breach of the order and you can go to jail for a year. And this order lasts for 5 years. So it's a significant change. It's aligned with the government's desire to disrupt the gangs as much as possible. It was a request from police, but it came right at the 11th hour. And by the time Cabinet had signed it off exactly where it wanted to go with this, the select committee process had finished. So there's been some legal experts in the Law Society, for example, who have said, well, we need to have public consultation on this. It's not like a minor amendment here. This is actually quite a big deal. It's likely to violate lots of protections in the Bill of Rights. It might be inconsistent with the rule of law. It could enable police searches, very invasive, potentially traumatic police searches that will impact innocent people. or people who are going about their law-abiding business in a home where, someone lives who's under a prohibition order. So there's all these red flags, I guess. My overall impression of this is it's not great lawmaking. It's also very good politics because ministers and the Prime Minister and the Justice Minister and the Police Minister have repeatedly said, well, we want to disrupt the gangs, and that's what we're going to do. So that's going to resonate with voters, and so that's a political win, really.
But just how sneaky is this to do this at the last minute and add this in?
Like I said, it's not good lawmaking, and it's a bit hollow for politicians to say, well, we're going to do it, and it's important because the police want it, and we want to support the police. Because, you've only heard from police about this, and the Ministry of Justice, the Ministry for Women, Te Puna Kōkiri, and the Privacy Commissioner. All of those latter agencies, by the way, were opposed to it because of all the reasons I outlined, the inconsistency with the rule of law, the violation of basic human rights, the potential for invasive searches that could be traumatizing. So there is no wider public consultation, which often uncovers other issues, unintended consequences. So, yeah, it is not good rulemaking, despite being good politics, and you could call it pretty sneaky.
What I find interesting, though, Derek, is he said no initially, then he changed his mind. Do we know why?
Well, we asked him that at Monday's post-cabinet press conference, and he didn't really give an answer. He just said that it's an iterative process. But it's clear in the documents that have been released that his initial cabinet paper in June did not include the private home ban. He hasn't really elaborated on why that was. He then added an appendix to that paper which included the home ban, and he justified it by saying that he wanted to enable those wider police searches. If you have a search warrant to go and search for a gang patch in the home of someone who is under a prohibition order, if there's a private home ban, then you can search the whole house. The offender can't just voluntarily surrender their patch jacket or whatever it is and say, sorry, here it is, and then the police have to go, essentially, because that's it. But with a private home ban, they can search the whole house because they're not allowed any gang insignia in the whole house. That means they might uncover drugs or firearms or whatever, but they have the whole house to search because any item found in the house at all would breach the order. So far more invasive searches, and also far more likelihood of prosecution, because without the home ban, if they found a patch in the house, then a flatmate could just say, oh, that's mine. So it does make the law far more, or this clause in the law, far more disruptive. So that was the justification he gave in the appendix to his cabinet paper. So, it's probably a fair bet to think that he just decided, oh, well, actually, I do think it's justified, even though there are all these red flags, which he's well aware of.
Yeah, it just sounds like a legal minefield. What are the gangs saying? Is there any feedback from gangs in response to this?
Not that I'm aware of. Interestingly, the Ministry of Justice was kind of worried that the risk of a private home ban would focus police resources on gang crimes that aren't that serious. And that kind of presumes that gangs are smart enough to say if they have a house where they have a drug operation going, that they remove all gang insignia from there. And anyone who goes in and out of the house can't have a gang patch on them in case that house becomes the subject of a search warrant or, someone who's the subject of a prohibition ban. It will certainly enable police to get under gang skin and disrupt the homes where they live. And that is, the good politics of it and what resonates and people will applaud that. Whether that actually reduces crime is a totally different question.
Politically, though, Derek, how important is this bill for National?
It's a big, big win. It reinforces, everything they campaigned on. It'll resonate with the base. It allows them to paint the opposition as cozy with the gangs, like the Law Society or anyone who opposes this bill might well say, look, it's not good lawmaking. Everyone has a right to these freedoms that are protected under the Bill of Rights Act. But that just lets the government say, well, these guys they're getting cozy with the gangs. And I think that's why the ministers involved and the Prime Minister, they're so unapologetic in supporting this. They know it's just a big win for them. They're not going to lose any votes over this at all. And you could probably say that for the broader law and order agenda.
They're saying we're getting tough and it's working for them.
Yeah, and it's also important to note that there's zero evidence that this will work. The Ministry of Justice have said that there's a really broad academic literature about harsher penalties having very limited, if any, effect as a deterrent. And police, in their advice to Mark Mitchell, the minister, even said the police have found no evidence that this will work. We just think it will.
Hold on. So why are they doing it? Is it just all lip service?
Well, like I said, it's a big win for them. And it'll appeal to the base. It'll appeal to the wider electorate. And it's probably important to note that no evidence it will work doesn't necessarily mean it won't work. But there are so many intersecting issues to do with crime that it's probably going to be impossible to know the direct impact of this on gang crime at all.
I'm interested because you've done a few stories on this. Feedback from the general public, what is the feeling out there? Are they for or against it? What are they saying?
Well, I don't usually dive into the comment sections in stories that I write, but I did have a look yesterday just briefly, and unsurprisingly, there's very little sympathy for the rights of gang members, and there is generally very high level of support for anything to disrupt gangs, regardless of, like I said, whether there's any evidence that it will affect crime or levels of crime. And I'm sure the government knows this, and that's why they're going so hard on it.
What is Labor's take on this? How are they responding?
Well, when the amendment was added with the private home ban during the committee stage, Labor obviously tried to get the amendment withdrawn. Labor's justice spokesman, Duncan Webb, called it an absolute dog's breakfast and a horrendous piece of legislation. He questioned why the punishment for breaching a private home ban had to be imprisonment, couldn't be a fine. He questioned why a court handing down a prohibition order had to be mandatory after the third offence rather than an option to, consider the circumstances involved. And he basically questioned whether it was an unjustified limit on people's rights and all the other issues that are raised in officials' advice. And Paul Goldsmith was in the House at the time, and he basically dismissed all of those comments, saying that the amendment was quote unquote appropriate.
What about Te Puni Kokiri? They've raised some serious concerns. Talk us through this.
Yeah, I mean, they echoed a lot of the Ministry of Justice advice as well, but they did raise in particular the potential risk for the unfair application on Māori. And just as a side note on that, the comments from ministers backing police 100%, and we know police do an exemplary job at lots of things, but we also know that police are not angels. Not all police are angels, right? And powers can be abused, and that's why we need good lawmaking. Like dawn raids anyone or... So, Te Puni Kokiri did raise the potential for unfair application on Māori. And they also, the other interesting thing that they raised that I thought was really interesting was the Royal Commission into Abuse in State Care, and whether the government was going to repeat the mistakes of the past. And I suppose that really hinges on whether you think that gangs are a product of the state, as evidence to the Royal Commission said. And if you do think that, and that might be a minority of people, but if you think that, and it's certainly a valid perspective, you probably think that the state has a responsibility to help those people, whether they're in gangs or have ended up somewhere else. But a lot of people and a lot of those gang members were in state care. And if you don't think that, then you probably think anything trying to disrupt the gangs is a good thing.
The Law Society doesn't think the bill's amendment is a good thing, and it has penned an open letter to Goldsmith urging him to withdraw it.
We highlight the issues about consultation. We also highlight potential issues with the Bill of Rights and rights like freedom of expression, freedom from unreasonable search and seizure. And if we cannot have the government agree to stop the amendment, we ask the government to consider at least making some changes to it to make it more effective. And I guess that probably seems a bit two-faced to some of your listeners, but the Law Society's focus is never policy direction. It's not for us to comment on the merits of whether something's a good idea or a bad idea, but we'll always be heard to comment on things in terms of constitutional norms, what we call the rule of law, so making sure that the law is consistent and consistently applied for all, and workability. And in that final category, we also had some concerns about the timing. But we submitted that the government's got it wrong in terms of how it calculates the timing of which the recent convictions are calculated.
Have you heard back from the minister at all?
Apart from the various media statements, no, I'm not aware of any letter coming back. But the media responses are very much along the lines of, oh, well, we had some feedback about enforceability from some agencies. I think the police have been highlighted. And we're not going to apologise for getting tough on gangs, which, with the utmost respect, is kind of an ends justifies the means argument. It doesn't address any of the very significant concerns that have been raised.
Chris, does the bill violate New Zealand's Bill of Rights, specifically around freedom of expression and, say, privacy?
There's concerns about that. And it's almost like when there's concerns and there are significant concerns that you need to consult the experts. And it's precisely why you'd go to select committee. But people need to be aware that a search power is near the most significant in terms of what the police have to intervene in our lives. So searching your home is at the top end in terms of what the state can do, and it has to be carefully justified. In the modern context as well, it's not actually just an officer turning up and knocking on the door and asking to see your gang patch. Owing to the way that our health and safety law quite understandably works and the way that our police are resourced, a search of a person's home, and particularly a gang member's home, is a big undertaking. And certainly if you're looking for organised criminal activity, if you're looking for evidence relating to a murder or big drug transactions or something of that nature, then it's quite easy to justify an armed offenders squad, multiple cars, multiple staff, safety proceedings, briefings, literally hours of work required both to background and then execute a warrant at a person's home. And in significant cases, I don't think anyone listening to this would shirk from that resource being expended. But when what you're targeting is a piece of insignia, a piece of fabric, a poster, a flag, a colour, presented in a certain way, a slogan, then you've got to have real concerns about what this means. So it's one thing to say tough on gangs, but you really do risk scrapping with the symptoms when you're talking about deploying the police's police search resources, as I say, near the more significant end, far from a simple exercise when it comes to searching people's homes, and particularly those with a gang history, deploying them after insignia. This would put a search for gang insignia on an easier platform or easier playing field than the police have in terms of searching your computer for child abuse imagery, child pornography and things. This puts the search for gang insignia on a similar platform to looking for murder weapons in a person's home or things of that nature.
And this is an issue brought up at a Beehive news conference fronted by the minister, that gang insignia is now rated as more harmful than terrorist symbols.
Is gangs worse than terrorism?
That's a silly question.
No, it's not, because you're not banning the use of terrorist symbols, and you're banning the use of gang patches. If someone kept rocking into Parliament wearing a swastika on their coat or whatever, would you be comfortable with police having powers to go into their home and find any other swastikas?
I wouldn't be comfortable with it, but that's for police to deal with. But what I'm focused at the moment on
But
is
you're
the gang
comfortable for
insignia.
police to do that with a gang member?
Yeah.
And so it really is, when you put it in those sort of terms, a real practical quagmire, at least, a real eyebrow raiser in terms of that's how the law is being proposed. And it's a policy direction, but it's a pretty significant direction when you view it in those practical terms. And the Law Society won't be heard on the practicalities in terms of whether it's the right policy or not. But when the issues are that significant and the proportionality questions that obvious, you would expect that it would be put out for consultation.
And what about family members living with gang affiliates? How do they protect their own rights?
I've raised this as a very significant concern. I worry that the amendment in this, I think the phrase they use is along the lines of, their usual place of residence. The whole concept of someone's a repeat offender, they have a usual place of residence, they're keeping a stockpile of these insignia there, and we're going to go and take it all off them so they can't display it in public anymore, is a very, I say, oversimplified view of how living arrangements actually are. And anyone with any experience at all of the social setting and scene in which gang dynamics play a role in this country will be well aware that you're not talking about necessarily a nuclear family, even a single family inhabiting one place as the usual place of residence. You're not talking in terms of mum, dad, 2.5 kids, a quarter-acre, 3-bedroom house with a bathroom kind of thing. The variety of living arrangements, family arrangements, and cultural and whānau connections from which these issues might arise is just beyond what I can describe in the time I've got this afternoon. And yet you've got this singular thing, a focus on a repeat offender, and a singular focus on gang insignia, and then the powder go into their home. So if you've got an old curmudgeonly uncle who was a mobster and for whatever reason takes the pip at the patch ban, but lives in a garage out the back of your place or in a bedroom with your kids and things, then your home could well be subject to these sorts of searches and things from the police. But this is exactly the kind of thing you'd expect expert consultation about. Will the wider impacts of people being searched, people being hunted out in their homes for what amounts to beliefs or groups that they might belong to or have supported, or a relative who might have supported it back in the day, is going to put them at odds with the state. And I just, when something that significant is changing, you'd expect that those much more equipped than me to speak to the topics, who have the expertise, the knowledge and the experience of these homes, houses and families would be able to make some submissions and help the government out, get it right. Look, if you really want to address the issues that we have with gang misconduct, how are we best to do that? And we're just not seeing any of that. We're just seeing tough on gangs.
All these things are designed to give police the extra tools to make life tougher for the thugs and gangs.
It's a good line for the government, but what are the possible grounds for challenging the bill in court?
I guess you've got two levels there. If it goes through and becomes law and people are convicted repeatedly and then want to challenge the ban, then they'll do so in the usual way through the criminal courts, and there may even be rights challenges and things. But at the upper level, which I think is possibly where your question's aimed, if this law does go through, or the amendment goes through into law, then the Law Society and others in a similar position will have to consider whether or not the issues raised, the constitutional issues and rights issues, are such that some action is required. And certainly in terms of the Bill of Rights concerns, there is room within the New Zealand courts for the High Court to make what's referred to as a declaration of inconsistency. So it may be, and I need to be very clear, nothing's decided, and this is nothing more than a legal option that I'm outlining for your listeners to assist, but it may be that either the Law Society and or others would be considering seeking such a declaration in the High Court. If that declaration is made, if the law such as it is found to be inconsistent, then there are reporting requirements on Parliament, but the Constitution in New Zealand is such that would be the extent of it. So the declaration would that is, officially recognise the inconsistency or inconsistencies. Parliament would be required to respond, so the public know that the government of the day is being held to account. But no one but Parliament can change Parliament's laws. And so the legal response, such as it is, would just be alerting people, formally recognising the issue, and then waiting and seeing if Parliament will react or not.
The bill should come into force at the end of November. That's all for today. The Detail is a newsroom production supported by RNZ and New Zealand On Air. Thank you to Derek Ching and Chris Macklin. This episode was produced by Davina Zimmer and Alexia Russell and engineered by Alex Harmer. I'm Amanda Gillies. Mā te wā.